Good day, honorable judges. I am standing in front of you, and together in this room are my co-counsel representing the claimant. May it please the court. The case stems from the decryption conducted between the messages exchanged of Bertie and Debussy. This happened after the bullying incident happened to Bertie. The decryption was made even if there is no suspicion to the person of Miss Debussy. Thus, we are here representing the petitioner, praying that the challenge provision, Section 4 of the POCO Act, be declared unconstitutional. In a democratic society, we all have a duty and responsibility to ensure that our democratic institutions would not have significant tolerance to any arbitrary laws and conducts initiated and implemented by our governing entities. Thus, we invoke the following primary positions of the petitioner. First, that the challenge provision is an infringement of right to privacy, and it falls under the ambit of illegal seizure and searches. For our second primary point, we invoke that the challenge provision fail to differentiate classes and people, as well as messages. For our third primary point, we invoke that the challenge provision is vague and it failed to provide proper safeguards for the protection of privacy in post-decryption period. Under our first primary argument, we invoke that the challenge provision is unconstitutional for violating the right to privacy of communication, as it does not fall within the ambit of valid exercise of police power, as well as even implying or even employing the legal principle of strict scrutiny test. The requisite of a valid exercise of police power was laid in the case of Morphy versus Moto, and it has the following requisite. First, an interest, a public interest as distinguished from the interest of a particular class, and the second requisite is that the means employed by the government must not be unduly oppressive and unnecessary. In the case of Dcmcc versus Secretary of Justice, the requirements or requisite in order for strict scrutiny tests to be present is that there must be a compelling state interest, and secondly is that the means chosen is narrowly tailored to accomplish such interest. Thus, these two legal principles, we invoke that the challenge provision failed this test, even if we concede that there is a valid interest from the state, or even if there is a compelling state interest, we invoke, or we are in the position that the challenge provision does not employ a means that is not unduly oppressive and unnecessary. And we have this following argumentation because the challenge provision does not have or does not set particularity when it comes to the person and messages intended to be seized or searched, as well as there is no period as to when the decryption process could be implemented. The second point is that the petitioner also invokes.
Sorry, counsel, question. You were mentioning, or your allegation is that the method or the means it's not narrowly tailored, right? And so in this case, if there's cyberbullying that's happening to text messages, how do you suggest or recommend that it be revised or this law be revised in order to address that particular scenario?
It is included in the another invocation or position of the petitioner, Your Honor. We agree to the fact, or we concede to the idea that the right to privacy of communication is not absolute. However, it must set a standard and safeguards, and such safeguards is already laid under the case of United States versus U.S. Districts Court of Eastern Michigan, as institutionalized under the Omnibus Crime Control and Safe Streets Act, Section 2518, and as reflected in the Section 3 of the Anti-Wiretapping Law. The following safeguards are as follows. First, there must be particularity when it comes to the name of the person, as well as to the communication intended to be intercepted or searched or even seized. And second is the offense committed must be in particular. And third is that there must be a period as to when the decryption could only be allowed to be implemented. And in the case at hand, those requisite or safeguards was not present.
Counsel, sorry, you used the US case.
Yes, Your Honor.
How are your US cases binding to this court?
Your Honor, the jurisprudence United States versus U.S. District Court of Eastern Michigan was a landmark case that sets the safeguards or was institutionalized under the Omnibus Crime Control and Safe Street Act 2518. And at the same time, it is reflected in the Section 3 of the Anti-Wiretapping Law. Thus, it is equivalent to the fact that the standards or metrics laid in such jurisprudence as adopted in U.S. statute or law, and at the same time reflected in our own statute, is an indication that such safeguard and standard will evidently safeguard or somehow lessen the implication or detrimental effect of infringement to the right to privacy of communication, Your Honor.
Counsel, before you proceed further, what's the necessity for the application of the strict scrutiny test in the first place? There is a presumption of constitutionality. What are your proofs that this particular statute has not met that presumption, or we should not apply the presumption of constitutionality?
Your Honor, we concede, even if, for the sake of argument, even if we concede that there is a compelling state interest, the petitioner is in the position that the means employed is not narrowly tailored, and to reiterate, it is because of the reason that the challenge provision does not set a safeguard and standard such as those mentioned under the Section 3 of the Anti-Wiretapping Law, and those are particularity when it comes to the name and communication intended to be intercepted. The offense committed must also be mentioned in particular, and at the same time, the period or the authorization as to regarding the scope of the decryption was also not laid in the case at hand, Your Honor.
Assuming that I agree with the point that you raised, we're talking about intangible, okay, cyber or internet, okay, decryption. So, if by analogy we will use the safeguards that is applied in warrantless arrest, for instance, by analogy, in order to validate the means employed, can you not use the standards of warrantless arrest for those that, for items, for example, that are on plain sight? And this applies to decryption in the cyber, scene.
Your Honor, in warrantless arrest, the requisite or the presence of probable cause is indispensable. Thus, in the case at hand, as stated in the facts, Ms. Dcmcc was arrested even if there was no suspicion in his person. Even if there is no suspicion that she committed acts violative to the welfare or to the betterment or development of the child.
But counsel, the arrest was premised on the decrypted messages, was it not?
Your Honor, even if such instance might be true, we are in the position that the decryption was invalid. Thus, any other evidence in accordance or attained in such manner was also...
That was what I was talking about earlier. Can we not use by analogy items that are seen on plain sight in the course of a warrantless search and seizure and arrest?
In the case at hand, Your Honor, it is not applicable because...
Why?
Because the decryption could be, the Section 4 of the POCO Act, the decryption could be initiated, could be implemented, even if there is no suspicion, even if there is no probable cause.
Okay, counsel, last question on this matter. The first component is the interest. That calls for the valid classification. Don't you agree with me that children deserves separate special treatment, considering that it is under human rights framework a vulnerable sector?
Your Honor,
Thus, valid classification.
Your Honor, as mentioned earlier, we concede to the idea that there is a valid state interest, even compelling state interest. However, it is not a justification in order for the means employed to be unjust, in order for it to be oppressive, Your Honor.
Hi, just a quick clarification. Are you challenging the order or the law itself?
we are challenging the Section 4, Your Honor. Just the Section 4 of the POGO Act, Your Honor.
Okay. What if you want to challenge for? Because it seems like your arguments are really focused on the court didn't do this or the means employed. Because I feel like it doesn't have to be challenged, especially for the means. I understand you're not challenging the what do you call this? The compelling state interest part, but what you're challenging with the means employed. But isn't this sort of like didn't the law sort of give this power to the judges to ascertain whether or not this particular means would be useful in this particular scenario? Because in this case, for example, there was a need to decrypt, right? So, and I'm just trying to grapple with the idea that aren't you really more challenging what the court did here? And just applying the law itself, another judge could have done the things that you're saying right now.
Your Honor, we challenge the law itself because of the fact that the order of the court, was falls under the ambit of a general warrant, Your Honor. Thus, as mentioned earlier, such issuance is invalid in the sense that it lacks particularity and specifications. We concede the fact, Your Honor, that there will be instances as to when. Okay. Your Honor, to mention, we consider the fact that there is indeed a valid state interest. However, we are still in the position, or we are firm in our position.
Sorry, just let me answer this quick question. You mentioned a while ago that there was an issue. You have an issue with the period of decryption. What did you mean by that?
Your Honor, the decryption process does not set or lay the standards. Meaning, even if there are messages there are message exchanges between particular individuals that happened prior to the incident or before the happening of a particular act or unlawful act or crime, it could be decrypted, Your Honor, because the law itself mentioned all messages shall be decrypted, Your Honor. Thus, we invoke that period shall be established or should somehow be present in order to safeguard that the challenge provision could not be employed in arbitrary manner, Your Honor.
Sorry, can you give like 2 minutes and then just make sure that the other one can get 2 minutes as well? What do you understand about decryption? And why I'm just trying to, I guess, get a sense of what you understand about decryption and how this would apply in this situation. Like, why is it an issue?
Your Honor, decryption, in a particular database, the messages exchanges between individuals are stored. Thus, in order for somehow to apprehend or in order to reveal particular conversation detail of the conversation, it must be opened in a manner that will somehow expose or reveal the message exchanges between the parties or the individuals affected or involved, Your Honor.
Okay, so if you challenge this decryption part, then that means if, let's say, we have a ruling that says that they can do decryption, then that pretty much makes all of the messages secret. And in that case, then having this idea of a warrant won't make sense anymore. Because unlike in the physical world, you can ask for letters, let's say, between you and me, or so. If you look for the physical copy, then you can really verify that it's between you and me. But when it comes to the decryption part, as you mentioned a while ago, it's like a lock. So unless you unlock it, then you will never know that it's going to be a message between the two of us. What I'm trying to say is it's a necessary step to understand whether the message is relevant to the case, is it not?
Your Honor, our position that there shall be a period is not affected by such instance that you raised, Your Honor. In the sense that when messages are decrypted, there are dates that could be seen. Thus, if the dates of the message exchanges was revealed and it happened prior or before the happening of the incident, it shall not be touched, Your Honor. So that's what we are trying to somehow proceed or invoke, Your Honor, that there shall be a period as to when the decryption process could only be applied or implemented, Your Honor.
Okay. Council, let me give you another example that is probably closer to this one, which is, for example, a warrant to disclose computer data. Okay, you serve the warrant upon application with the RTC, and the RTC serves it on, for instance, banks, financial institutions. Upon securing, in this case, upon decrypting the computer data, that's the only time that you can filter. Okay? So assuming, following your line of argument that, of course, indiscriminately, the data will be presented to you whether relevant or not to your case, don't you think, okay, assuming that I follow the same line of argument, that it outweighs whatever risk there is to possible data privacy violation, if you may want to term it violation, as against protecting a potential risk or danger to a vulnerable sector, which is children?
Your Honor, to reiterate, we surrender or we concede to the fact that the right to privacy of communication is not absolute, Your Honor. However, we should not dispense the safeguards laid in under the Section 3 of the Anti-Wiretapping Law, as well as in U.S. jurisprudence we've mentioned earlier. Thus, even if we consider the idea that there is a valid and compelling state interest, Your Honor, the position of the petitioner is firm that safeguards regarding the infringement, the right to privacy of communication must not be infringed in a discriminatory and oppressive manner, Your Honor.
Just a final note on that, Counsel. You are saying that it is your position that the right to privacy is greater than the right to protect children, human rights of children.
Your Honor, no, we do not adhere to that idea. However, we adhere that even if there could be infringement of the right to privacy of communication, it must be, the standards of safeguards must not be absent, Your Honor. And in the case at hand, Your Honor, any safeguards to somehow lessen the detrimental implication of the infringement is not present, Your Honor.
Excellencies, good day. May it please the Court. I am Aaron Hill Angero Bitong, the first speaker on behalf of the side of the respondent, the Office of the Solicitor General. With me are my co-counsels, Mr. John Francis Gaza and Ms. Natasha Carrion. As the first agent, I am tasked to discuss the respondent's prayer for closure and dismissal of the case filed for this court by the applicant, Ms. Amanda Debussy, alleging that Section 4 of the Protection of Children Online Act, also known as the POCO Act, is unconstitutional. Your Honor, with due permission, the Council would like to mention the time division for the oral arguments. Your Honor, 4 minutes will be allotted for the first speaker, 8 minutes for the second speaker, and we will reserve 8 minutes for our rebuttal. Your Honor, the Council seeks permission to now proceed to the main argument of the instant case. The present case deals with the tension between the state's compelling interest to protect children against online abuses through POCO Act and the right to privacy of an individual. This case specifically focuses on two main issues. First, the legislation to protect children is a valid exercise of police power of the state, and second, it is the state's commitment to protecting children's rights under international treaties. With that said, we raise the respondent's first argument that Section 4 of the POCO Act is a valid exercise of police power, therefore it is constitutional. The POCO Act was promulgated in response to a cyberbullying scandal that garnered nationwide attention in January of 2021. This act aims to protect children against cyberbullying and other forms of harassment in order to protect their safety and mental and physical well-being. In the case of Ermita versus Mayor of Manila, the legislative bodies of the government, whether at the national or local level, are primarily responsible for exercising power, police power, which involves creating regulations to promote the health, morals, peace, good order, safety, and welfare of the people. Based on this jurisprudence, we raise that Section 4 of the POCO Act is a valid exercise of police power, as it was, in this case, in its legal rights, enacted by the Philippine Congress to protect children against cyberbullying and other forms of harassment in order to protect their safety and mental and physical well-being. Furthermore, it must be noted that the requisites for a valid exercise of police power are that, first, there must be a lawful subject, and second, that there must be a lawful means employed that are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. In this case, the interests of the minor children are invoked through and the incapacitated individuals who are susceptible to the dangers of the largely unregulated cyberspace. Moreover, the means are also reasonably necessary as the single order decryption of messages are only enforced upon sufficient risk, taking consideration to the right to privacy as enshrined in Data Privacy Act of 2012. Minors, unlike adults, are in need of guidance from their parents. Hence, the said pertinent provision.
So the applicant already conceded that there is a compelling state interest, so there is a lawful subject for them, so they're not disputing that. What they're disputing is the means. It says here in paragraph 11 of the problem that the order that was granted produced or was used to decrypt and review all. So all of the messages on Bertie's phone. So it wasn't a certain period as the applicant would say or would forward or submit, and it's also not towards a particular person. So if this was a cyberbullying case, wouldn't it be more logical for the court to have granted, pursuant to this law, that for the court to grant that, okay, this is the specific period, we're only going to be reviewing this specific person because it's the person that you are alleging has bullied you. But according here, all of the messages on Bertie's phone was exposed. So how do you address that vis-a-vis the right to privacy that Ms. Debussy is alleging?
So the POGO Act is in adherence to the lawful procedure. In reinforcing the constitutionality of Section 4 of the POGO Act, it is important to take note that the provision, when carefully investigated, actually adheres to the lawful procedures provided by the Data Privacy Act of 2012. Section 13 of the said statute delves into the processing of sensitive personal and privileged information. It specifically states in the following that sensitive personal information and privileged information, the processing of sensitive personal information and privileged information shall be prohibited except in the following cases. That the processing is necessary to protect the life and health of the data subject or another person, and the data subject is not legally or physically able to express his or her consent prior to the processing. So in the present case at hand, the decryption referred to the Section 4 Act is actually valid within the ambit of the Data Privacy Act because it contemplates a justified act due to the criteria set forth by the provisions of the said statute. This includes the fact that the party is a minor and cannot legally or physically express his consent prior to the decryption of his own messages. Also, the decryption is valid and in processing of information is not prohibited in line with Section 12D in relation with Section 13C that the processing should be necessary and important for Bertie's interests as one of the data subjects, including the caretaking and safeguarding of his rights to life and
Sorry,
property.
Counsel, I don't think it answers my question because the question isn't whether or not Bertie was able to give consent. It wasn't the question. The question was, it is the reviewing and decryption of all of the messages on Bertie's phone. So isn't it more, wouldn't this whole case be dispensed with if only the POCO was able to give us sufficient standard as to what is supposed to be decrypted, what period, as to who? Because here it says all of the messages. So do you agree that all of the messages on Bertie's phone should have been decrypted?
Yes, it should be decrypted, Your Honor, because in order for us to know the sufficient, it is stated here that there is sufficient risk is the standard in order to have a lawful court order, in order to have a decryption of the messages. In order for us to know that there is sufficient risk, it is important to us that all messages should be decrypted because it is absurd to just base it on suspicion that one's message is not related to bullying. So therefore, all messages should be decrypted, Your Honor.
Sorry, Counsel. How do you define sufficient risk and what's your legal basis?
Sufficient risk in this case is that in section 3 of the Philippine Constitution, it states here that rights to privacy and of communication and correspondence is inviolable except upon lawful court order, and upon public safety and order as prescribed by the court. So public safety here is sufficient risk here is the cyberbullying. So cyberbullying is included in the POCO Act as it aims to protect children from cyberbullying and other forms of harassment, and to protect their safety and well-being. Therefore, sufficient risk here would be considered as an exception to the rights to privacy, as it is related to public safety.
Counsel, sufficient risk enough to violate the constitutional right of Ms. Debossi to be arrested without any suspicion or probable cause, which is at least the minimum for preliminary investigation. What do you think?
Well, sufficient risk here would not be, it is stated here in the POCO Act that sufficient risk, that the court would only order court order for the decryption only upon sufficient risk. So therefore, upon investigation and upon thorough investigation of the judge, sufficient risk that there is cyberbullying and that there is danger to the safety and well-being of the child, then therefore, yes, sufficient risk would
But counsel, you agree with me that the context within which Section 4 of the POCO Act is being questioned is in relation to the arrest of Ms. Debossi, related to the decryption of the messages that included her messages to Bertie. So in that regard, what particular safeguards are there that would deter any abuse in the application of Section 4? It might be a tool for fishing expedition, for example.
So it is not expressly stated here in the POCO Act that there is standard to
That's right.
yes. However, we argue, Your Honor, that when there is ambiguity, we rule for the statutory construction. That when there is ambiguity, we rule for the intent or the spirit of the law.
Do
Which
you agree, counsel, that the provision in particular is ambiguous?
there is no clear. However, there is no standard.
So is the provision ambiguous?
Not necessarily the whole provision of Your Honor. However, there is no clear-cut standard as
So
to.
it is vague.
No, Your Honor, it's not vague. It's not vague, Your
In
Honor.
what sense is it not vague? If you're saying that there is no standard, you accepted the fact that you admitted that there is no standard. You may clarify, please.
It is not vague because it was clearly stated that what will happen to the decrypted messages procedures were given and where it will be stored and what is being searched is more of potential harm to a child. It would be impractical to apply the particularity of the description because it describes the communication of correspondence to be seized. As cyberbullying is an extraordinary circumstance which calls for extraordinary measures. But the identity of the persons whose communication is to be intercepted, the identity of the offense sought to be prevented, and the period of authorizing given can be specified.
Hi. So, we do need to look at other laws, I guess. What are your thoughts on rules and evidence, if ever? Are these things, is the structure or is the framework under the rules of evidence, can we use that to supplement, if you have any thoughts on this, can we use that to supplement whatever issue applicants have with respect to the needs, just in case?
Apologies, Your Honor, I haven't taken evidence.
Okay, understand. Okay, let's go with, they have been mentioning a while, they kept on harping on the decryption and encryption. What do you understand by this concept? And how would the technical features of that assist the government when it comes to at least understanding the law. So because I know at the end of the day, as part of the Supreme Court, we do need to understand where the options, make sure that there's all the tests have been met, and also just to consider whether there is a way for this court to still not find that this is unconstitutional.
So, as defined in Section 6 of the POCO Act, decryption is unlocking messages that are unlocked within the encryption mechanism of an information society service provider so that the police and the child services can read through the situation in order to help the child. This provision will mean that agencies such as PNP and the SWD here are able to access those messages if and it becomes necessary. And by mandating that the information society service providers to develop and maintain a way to decrypt these messages, this will ensure that we can identify and track down those messages and those perpetrators who may do harm to our children.
All right, thank you.
Further, the contention of the applicant. POCO Act, Section 4, violated the Equal Protection Clause. I will explain. According to Section 4, POCO Act, the order may require the owner of that device to allow the PNP or DSWD to take a copy of all encrypted messages stored in that device. The requisite of the Equal Protection Clause, the classification to be valid, there must be a substantial distinction. Second, be adjournment to the purpose of the law. Third, not be limited to existing conditions only. And fourth, applied equally to all members of the same class. In this case, Your Honor, the first requisite is lacking substantial distinction. The challenge provision fails to establish as the distinction of person, particularly between the persons in good faith or with ill motives. Second, Section 4 does not distinguish as to the time, particularly between messages sent by 5 years ago, 10 years ago, and messages sent 5 days ago, after the possible cyberbullying incident before the decryption. Therefore, it is clear that challenge provision embrace.
Hi, sorry. But that's not really a typical issue or matter addressed in a law, right? Isn't that more of a judge type of thing? For example, can you maybe assist this court in pinpointing like a specific law, for example, that would say that all warrants should have this time period? Isn't this more of a rules of procedure kind of thing?
Actually, Your Honor, that's why the POCO Act fails to give this substantial distinction because, Your Honor, according to our statutory construction, where the law does not distinguish, when the law does not distinguish, neither should the court.
Sure, but there are instances in which the span of the crime spans like years. It could be 2-3 years. It can be because it seems like what you're trying to address here is you're challenging the constitutionality based on the facts right now, which I understand. But also we need to consider as a court that this law should apply to all cases in all instances. And there will be issues in which messages could span years, for example, even decades. So I guess my question is, it kind of makes sense that the law will not mention it. Rather, it's really more of a judge type of order that, anything that involves this particular matter, involving this message, maybe within the span of time of whatever it is that was claimed in the information or in the complaint, right?
Yes, Your Honor, but even if the judge can give some discretion for issuing the decryption order, this still violate, Your Honor, the substantial distinction. Because, Your Honor, I will reiterate that when the law does not provide, neither shall the court, Your Honor.
Council, sorry, just to piggyback off my co-panelist here, because here, shouldn't you be contesting the order of the judge instead of the constitutionality of this law? Because here, the way that I see it, the way that I read it, there is a standard, which is it's up to the discretion of the judge. So there is a presumption of regularity when it comes to how the judges are supposed to dispose or to execute their authority and their obligation. So shouldn't the issue here be whether or not the judge's order of decrypting all of the messages was proper and not the constitutionality of the law, since the law was pretty clear in saying that, okay, we're going to give that authority and power to the judge to make that determination and to make that order?
I concede with that, Your Honor, but even if
Sorry, Council, you're conceding that we should be, that the constitutionality is not the problem and it's the order?
no, Your Honor, I consider that the discretion of the judge or by giving the order to this decryption, even the judge have the discretion by ordering of decryption, Your Honor. The Section 4 POCO Act does not distinguish as to the time, because, Your Honor, the issue is not ended when the process of decryption. What are we pointing here right now, Your Honor, is after the decryption, how the state will safekeep, will protect the persons affected, and also the messages decrypted, Your Honor.
Yeah, but then that's a very interesting point. I'm just wondering, in that case, once they decrypt the file, wouldn't the other constitutional provisions apply? For example, you have unreasonable search and seizures, you can exempt or exclude certain pieces of evidence, so you still have those. So I guess what I'm trying to say is, enacting the POCO doesn't mean that the Constitution wouldn't apply anymore. You still have that framework, right?
Yes, Your Honor.
And so how, and I guess, so now my question would be, could you assist this court in understanding that particular aspect? Because if we are minded to say that this provision, for example, is unconstitutional, we also need to be convinced that it's unconstitutional because we couldn't find a way to justify why this law should still exist. Considering that we already have like existing frameworks, existing safeguards that we can definitely apply here, unless you're arguing that we cannot apply those or those are inapplicable. So maybe you can assist the court in sort of navigating through that. Thank you.
Actually, Your Honor, it is clear that in this case at hand, there's a infringement of right, and there's a power of the state of strict scrutiny. Then I will repeat the argument of the first speaker, Your Honor. By employing the strict scrutiny test, it should be the state interest, but the being a narrowly tailored is not present in the POCO Act.
Counsel, going back to the case, what is the probable offense committed against Bertie here? Cyberbullying, do you agree?
Yes, Your Honor.
Okay. And in relation to the coverage of the decrypted messages that included Ms. DeBossi's messages to Bertie, don't you agree that that is quite justified? Because cyberbullying does not only take place in one instance, in just one date or week or month. It can spread throughout the entire year, years, right?
Yes, Your Honor.
So, is that not enough justification? Going back to your original premise that it's quite indiscriminate in terms of coverage. That's why you needed standards to streamline.
Actually, Your Honor, we're assailing the Section 4 of the POCO Act here. Yes, Your Honor. So,
But in what sense? In the sense that it does not provide sufficient safeguards for other private messages decrypted. Is that correct? Did we understand it correctly?
yes, Your Honor.
Okay.
And as to the person, Your Honor.
Yes, as to the person.
And
But
as
you
to-
would agree with me that cyberbullying can take place in a span of many months and even years, and may cover not only just one particular person, but several persons or even a group of persons.
Actually, Your Honor, the state is not have the right to protect the children against the cyberbullying. But the
I'm sorry, can you clarify that, counsel? The state is not under obligation to
No,
protect children from cyberbullying. Can you please clarify
Your
that
Honor,
statement?
we concede that the state have the duty to protect the
Okay.
children. Okay.
Let's just be clear on that.
Yes, Your Honor. But the reasonable means is not present in this is not present in the POPO Act, Your Honor, because again I will read section 4. Section 4, paragraph 5 states that this section shall apply whether or not the information society service provider retains copies of such messages. Nothing in this section oblige service providers to retain copies of messages sent. So it does not give us the standards and the protection of, Your Honor.
Maybe we can take a step back. You kept on mentioning, sorry, what are the tests involved when you challenge a law on constitutional grounds? What are the standards or the tests that this court could rely on or use?
First, there should be a compelling state interest, Your Honor.
No,
Okay.
maybe I'm referring to like the general test. So, but I think I heard someone somewhere said strict scrutiny. What are these tests, if you can recall?
This test, Your Honor, is the test in strict scrutiny. There must be a state compelling interest, Your Honor, but it must be narrowly tailored as to the implementation of the law, Your Honor.
Perfect. And then what are the other tests? So you have the strict scrutiny. And what are
Police-
there others?
Police power,
Say again?
police power, Your Honor.
Okay. How about rational basis? This is ring a bell. Rational basis test review, if any. Because it's very interesting how you kept on mentioning strict scrutiny. So I wanted to know more about this and how sort of this helps you in your case. Could you tell us more about maybe other tests and why you think strict scrutiny applies here instead of other tests, if any? Because I guess we're all kind of, we need to jog our memories, maybe we need to remind ourselves of what are these tests.
Your Honor, I will stick to the strict scrutiny test because this is our argument to we think that our client being violated because the state does not exercise the strict scrutiny test. It is lacking, Your Honor. It is lacking.
Okay, understand. So let's go to the compelling state interest as you mentioned. Isn't this too high a bar or a requirement from a test? Aren't there like so many cases out there saying that, oh, if it's the government, we need to make sure that we need to somehow bend over backwards to sort of say that this is constitutional, so long as there is rational basis or rational reason or some reasoning from the government, then shouldn't that apply? Why are we being too strict with the government here?
Your Honor, because according to the law, the strict scrutiny test must be followed. Right?
Now, I understand. But there are also cases in which strict scrutiny does not apply, right? So I'm just wondering if there are cases, if at least you're familiar with any cases, that would sort of tell this court that, okay, maybe you're being too strict with the government. Maybe you should give them some leniency. Because after all, you have, like, the courts, for example, they can sort of, make things, streamline things, maybe they can fill in the gaps, sort of. Is that a thing? Or is it double downing on, anything that the government does, courts should be strict when it comes to interpreting it, especially when it comes to challenging the constitutionality of those?
Actually, Your Honor, I don't have any jurisprudence regarding that, Your Honor, but I'm holding the requisite of the Equal Protection Clause written in the Constitution. Your Honor.
Okay, understand. Thank you. Go ahead.
Furthermore, Section 4 of POCA is vague because Section 4, Paragraph 5 states that the section shall apply whether or not the Information Society Service provider retains the copies of such messages. Nothing in this section obliged service providers to retain copies of the messages sent. According to the Estrada versus Sandigan,
Yeah, sorry. What about, is it Dcmcc versus Executive Secretary? Yes, right. I think in that case, the court already said that it's fine for telcos to do certain things like record, I think, for 6 months. Is that right? What about that?
I'm sorry.
Would you be familiar with the Dcmcc case versus, I think, Executive Secretary?
No, Your Honor.
Okay, but continue though. Maybe it's relevant to what you were gonna say. Sorry about that. Go ahead.
I'm establishing here, Your Honor, the vagueness of the.
Okay, go ahead.
Okay. The case of Estrada versus Sandigan Bayan, the doctrine of vagueness. The law suffers from vagueness when it lacks comprehensible standards that men in common intelligence will be able to understand.
Okay,
Then-
maybe, I'm sorry for interrupting you, but maybe you can give us like 2 sentences. What's the argument here? If you can summarize your point here in the vagueness. Thanks.
The Section 4 is vague because it does not provide what are the messages to be decrypted, what is the period of the messages to be decrypted, Your Honor, and the person to be subject for decryption, Your Honor.
Your Excellencies, good day. May it please this honorable court. My name is John Francis Gasa, the second agent speaking in behalf of the respondent. As a second agent, I will be discussing the supporting arguments for the respondent, as well as some of the findings from the applicant's arguments. Your Excellencies, the Council would like to request the permission to now proceed with the submission. Thank you, Your Excellencies. My co-counsel earlier have mentioned or presented that the POCO Act is a valid exercise of police power. In furtherance of this assertion, we present the following point for consideration. In constitutional law, it is a well-established doctrine that the government may be considered as having validly exercised its police power if only there is a concurrence of a lawful subject and a lawful method. Your Excellencies, since the applicant conceded that indeed there is a lawful subject in this case, the Council would like now to proceed to the lawful.
It doesn't matter whether they concede that. I still want to listen to this because at the end of the day, we need to be convinced that. Actually, I'm gonna ask the same question. Would you be familiar with any of the tests when challenging a law, like a constitutional challenge to a law? All these tests.
Yes, Attorney. Yes, Your Honor. The test that was to challenge the constitutionality of the law is that, as I mentioned earlier, that if the law if only there's a valid exercise of police power, there must be a concurrence of a lawful method in a lawful subject, Your Honor. So,
But that kind of sounds like a rational basis test, right? Would you be familiar with all these different tests, by the way?
I'm sorry, Your Honor, but I
Rational
cannot.
basis, strict scrutiny, intermediate.
I guess, Your Honor.
Okay, could you at least maybe quickly discuss those 3 if you're familiar with it?
So, the first test, Your Honor, is the strict scrutiny test, Your Honor. This states that there must be a compelling interest for the state to interfere with the property and liberty rights of the people. The intermediate scrutiny test, Your Honor, is there must be an important interest of the state to warrant the interference. And the last one, the rational basis, Your Honor, is that there must be a rational consideration or a rational significance for the state to interfere with the property and liberty rights, Your Honor.
Okay, and then of the 3, which one do you think should apply here?
Your Honor, the counsel for the respondent would like to argue that the level of scrutiny must be the strict scrutiny test, Your Honor.
Okay, so you agree with at least with the test?
Yes, Your Honor.
They should be applied. Okay, and then assuming that's the applicable test,
Yes, sir.
whose burden is it to justify the constitutionality?
Your Honor, the burden rests upon the applicant, Your Honor, to prove that there's an infringement or unconstitutionality of the law, Your Honor.
Is that really his case? Isn't it like more of a sliding scale when, rational basis is the test that's more favorable to the government, for example, and then the strict scrutiny is the one in which government must really show?
I'm sorry, Your Honor, pardon.
Isn't it more of a sliding scale in which rational basis is like the lowest of them all, the lowest threshold, in which government is sort of given like some leeway so long as you can justify it, and then strict scrutiny is like the highest threshold in which it is now the government's burden to show all these things that you were mentioning. That's why it's called strict scrutiny. Is that how we should be looking at all these tests? Or do you think all these tests are pretty much the same? What you just mentioned a while ago, the rational basis, intermediate, and strict scrutiny. What are the differences? You already mentioned the differences, right? So then you mentioned strict scrutiny would be the combining state interest, I think, if I recall it. So, and is it right? Your argument is the burden does not shift, meaning it's still the applicant's burden to show, at least when it comes to the compelling state interest portion? Or is it not your burden to show that you do have the compelling state interest?
Your Honor, I would like to argue that the burden rests now upon, in regards to the strict scrutiny test, the burden will now be upon the respondent, Your Honor, to prove that there is indeed a compelling interest for the state to interfere with the rights of the individuals, Your Honor.
Perfect. And that's the reason why, even if they conceded, I don't want you to just say, okay, they conceded, so let's not talk about that.
Okay.
I still want you to talk about it. So can you convince this court?
Yes, Your Honor.
Go ahead.
So, Your Honor, I would like to proceed to my submission. So, as what I've mentioned earlier, that the government may be considered to validly exercise its police power if only there is a concurrence of a lawful subject and a lawful method. The counsel for the respondent would like to argue that the POCO Act satisfies this requisite. The POCO Act possessing a lawful subject and employing a lawful method. A lawful subject means that there must be an interest, that the interest of the general public must require the interference of the state. Now, in the instant matter, the POCO Act is promulgated in response to the prevalence of cyberbullying that has garnered national attention in January 2021. The United Nations International Children's Emergency Fund, or the UNICEF, has released a poll that reveals that 1 out of every 3 young people in 30 countries, including the Philippines, have been subjected to online bullying. Now, the same poll shows that one out of 5 young people have missed school due to the online violence and bullying they have faced. The effects of violence against children, including the online bullying or cyberbullying, are severe, leading to lasting emotional and psychological scars and physical harm to our youth. Now, cyberbullying is unquestionably stands as a matter of paramount concern for the general public, necessitating a proactive interference from the state. Considering the relevance of the cyberbullying and its detrimental effects on the youth, constitutes a public interest warranting the state interference. Thus, we firmly argue that the POCO Act possesses a lawful subject, thereby satisfying a crucial criterion for a valid exercise of police power. As to the lawful method, Your Honor, addressing the issue of cyberbullying is particularly challenging as children are vulnerable and has easy access to the internet, rendering them easy targets to online violence. Children are connected online, so bullying no longer ends when they leave the school premises. The POCO Act stands as a pivotal legislation designed to safeguard the digital spaces where children interact. It introduces a proactive and targeted approach to safeguard children's well-being in the digital age, addressing gaps in the existing laws that may not adequately cover the complexities of online interactions, particularly concerning cyberbullying. While traditional laws may offer some level of protection in physical environments, the pervasive nature of internet presents a unique challenge and risk that necessitates the specialized.
Hi, Agent. Sorry.
Thank you.
I think we all acknowledge the interest.
Yes, Your Honor.
I guess what you need to convince us of is the compelling government interest, because there is interest on one hand, and there's this compelling one. So just what I'm trying to say is, don't forget the adjectives, and there's a reason why we had to go through this like a sliding scale, like there are different tests, because what you're arguing right now are really closer to a rational basis test. Because of the strict scrutiny, there's a higher threshold. So I guess convince us more is what I'm trying to say.
Yes, Your Honor. So as what I have stated earlier, Your Honor, there is a poll that shown in this case that 1 out of every 3 young people in 30 countries have been subjected to online bullying, Your Honor. 1 in 5 young people have missed school due to online violence and bullying they have faced. And other researchers, Your Honor, suggest that bullying sometimes result to a more detrimental effect on our young people, Your Honor.
Okay, and then so how would POCO address all of those? And why is this the least invasive? Maybe we can focus on those 2 points. How would POCO address those things that you just mentioned? And why is this the least intrusive of them all?
Yes, Your Honor. So the matter that is present in this case, Your Honor, is cyberbullying. Cyberbullying is a matter of an extraordinary circumstance, Your Honor, because given the environment of cyberspace, it is a complex interface, Your Honor. So, in order to address cyberbullying, Your Honor, the POCO Act effectively suggests a method that the decryption of message will effectively identify if whether or not there is a bullying happened between the encrypted message of the parties. Your Honor, I'm sorry, I would like, if you would allow me, would like to request for an additional time of 4 minutes, Your Honor.
No, just 2 minutes.
2 minutes. Thank you, Your Honor. Yes, Your Honor. So addressing the cyberbullying and this prevalence, Your Honor, and given that the complexities of the cyber realm, Your Honor, it is important to understand that the POCO Act suggests a method that fulfills or fills the gap that lacks in the existing laws, Your Honor, because other laws that addresses bullying, Your Honor, is only applicable to the academic institution, into the plain sight, Your Honor. So we impose the question: what about those environment outside of academic institution is in other than the plain sight? For example, the cyberspace, Your Honor. This is what the POCO Act is trying to fill the gap, Your Honor. The protection of children in a very complex environment of cyberspace, Your Honor.
Sorry. So can we go back to the facts again? Which messages are they going after here?
Your Honor, based on the facts, Your Honor, the messages subject to these laws, Your Honor, is the messages that has potentially contains an act of bullying, Your Honor.
Is it the message between the 2, or is there a specific message here on this one?
Your Honor, it is not Your Honor, the subject for this, Your Honor, is the messages between Bertie, the subject, Your Honor, and those people, Your Honor, that is potentially have incurred some kind of act, Your Honor, that would warrant for the decryption of messages.
Oh, sorry. Final question. I'm so sorry. Just a quick one. Why can't just get the, why is there a need to decrypt when they could just get the phone, for example, or whatever platform that was used? Is what I was wondering.
Your Honor, as I said earlier, Your Honor, the environment of cyber is a very complex interface, Your Honor. So, the mere confiscation of the mobile phones, Your Honor, or the gadgets, Your Honor, will not be germane, or will not be germane to the purpose of the law, which is to combat the cyberbullying that lies behind the encrypted message, Your Honor.
All Alright, just 15 seconds just answer this. You mentioned a while ago that the messages that were decrypted are those that were connected to the cyberbullying case, right?
Sure.
However, here in paragraph 11, it says that among the messages that were decrypted are messages between Bertie and his family. So how do you address that specific fact vis-a-vis your argument or submission that it was only those messages that were connected to the cyberbullying case?
Yes, Your Honor. It is indeed that the messages subject to this is that those only potentially have cyberbullying, Your Honor. However, Your Honor, to fully investigate and review the facts that would that result to the cyberbullying issue in this case, it is also important, Your Honor, to have an overview of other messages or contents, Your Honor, that is still relevant to the issue, Your Honor.
Final question.
Yes,
Just
Your
a
Honor.
quick answer to this. Going back to the least restrictive means.
Yes, sir.
Don't you think that there should be a layer of safeguard there before proceeding to actual decryption of indiscriminate decryption of all messages, like a preliminary step there in order to filter, to streamline which ones to actually decrypt?
Your Honor, it is stated in this case, Your Honor, that there's a judicial oversight that has been provided by the law, Your Honor. It is stated that the court shall only order a decryption if it deems that there's a sufficient risk to the health and mental or physical safety, Your Honor. This mere judicial oversight, Your Honor, would ensure the protection of individuals from an arbitrary flexing of the government's muscle, Your Honor.
So, counsel, just so we are on the same page, you are saying, and you will agree with me, that the discretion lies on the judge issuing the order, but from the perspective or taking alone the perspective of the risk to the child, not necessarily the point of view of any potentially affected sender of messages.
I'm sorry, pardon me.
The point of view taken by the judge issuing the order is the point of view of the child who may be affected by the risk of danger of cyberbullying, and not the point of view of possible message sender.
No, Your Honor, I would like to argue that the point of view should be rest upon on the point of view of the person, which is the victim
The
of
victim.
the victim.
Okay. Thank you.
That's the first point, so address that. Shouldn't we protect our children? They're vulnerable, thus, if there are any signs of bullying, then let's look at it, right? Number one, that's the number one point I made. Number two, the judge made a determination, right? Isn't that enough safeguard already? Therefore, if there's there's that safeguard, would it be like an overreaction to challenge the law itself? Why not just challenge the judge's ruling that there could have been a decryption? Why challenge the law? So those are the 3 points that I would like you to summarize for your group, at least on my end. If there are other points that the judges want to clarify, maybe we can. Perfect.
Honorable judges, I'm here as the final speaker of the applicant side, and I'm here now to address the points. Perfect, because all those two questions that were mentioned by our head judge is also relevant to what I'm going to say. So, in this case, we have an interest. We also, in the applicant side, recognize that there is an interest. However, this is no more compelling because all our existing penal laws already provide for those evil that is sought to be prevented by the POPO Act. It is already split into some few special penal laws, such as the Anti-Bullying Act, which seeks to protect children from bullying, and we can bridge that into the Cybercrime Law and the Data Privacy Act, which also, in turn, addresses the rights to privacy of individuals, which are now relevant in this case that we are in the technological world. So now, in this case, also to address one of the questions that our judge has also asked earlier. So how do we now distinguish this? Now, in the applicant side, we are here to argue that there is an unreasonable POCO Act speaks of protection of children online, which does not end on decryption itself. There is a time frame from before decryption to decryption, and then there's also a time frame to protect from decryption after or post decryption, Your Honor. So now, this is what we are contending in the applicant side. This is what is missing. This safeguard for this time period after decryption is what is missing in the POCO Act. Now, for
Counsel, if I may just interrupt, are you not going beyond the coverage of the law? Because you already mentioned and highlighted that the title of the POCO Act is mainly for the protection of children. And now you are revolving around the post-decryption. And I suppose that will focus more on the protection of the sender of messages and not really revolve around the protection of the child.
Yes, Your Honor. Thank you for raising that point. Also, because for our decryption, for this instance, this is the, where Section 4, Paragraph 4 comes on the decryption of on the provision that says that the owner may the law enforcement may require all the owner of messages which are stored in the device to decrypt all messages without distinction. However, we need not decrypt all messages because there is this thing called time-based encryption scheme in which we can determine the time of decryption while not decrypting all messages, because that provision that says all is already being interpreted. We should interpret it in the most common in its most common meaning. Now, I'd like to reiterate what my said, that would be like non-distinguished debemos, or where the law does not distinguish, neither should the court. So in that problematic provision, Your Honor, we are now addressing the word all, because we should not decrypt all messages that were sent 5 years ago, let's say 1 year ago, but only those which are relevant to the crime, possible crime that is committed, which is cyberbullying. Okay.
Can we go back, counsel, to the discretion of the judge? It is the RTC that issues the order. Should we not leave it to the discretion of the judge? The POCO Act provision is not necessarily an unbridled, decryption of all messages. If the discretion of the judge would, come into play.
I'd also like to contend that we should strike out that provision because it is already, there is a less restrictive means that is already governed by the issuance of cyber warrants in Section 6.1, which says that the judge, it was mentioned earlier that the judge, upon determination of some things, can also issue an order, a similar order that is provided by the POCO Act without sacrificing the rights of our individuals' rights to privacy. In this case,
I'm sorry, Counsel, can I expound on that? Okay, so let's just backtrack a bit. So you want to strike out Section 4, which says, a section in Section 4 which says that such order shall be made by the court.
No, we're not.
So what do you want to strike out?
We want to strike down the provision that says all messages, and also we want to strike down the provision that says nothing in this section shall oblige the service providers to retain a copy of these messages, because this is now bridging to the void for vagueness doctrine that is being
Okay. Do you mind assisting this court in letting us know where here, when you said all messages, what part of the problem it's located at?
For decrypting of all messages, it's I think it was already reiterated in paragraph.
In what
11.
paragraph?
Paragraph 11 that says that
Paragraph 11 is statement of fact. It's not a statement of the law.
There is this decryption on Section 4, Paragraph 4 of the POCO Act, which says that the owner of the, the law enforcement may require the owner of the device where the data is stored to encrypt all messages. Now this is unconstitutional as to the inclusion of the word all, because it does not distinguish as to time, because we can resort to less invasive means.
I understand.
That are
Let me just reiterate what AD mentioned. So it says here that it's by the order of the court. So isn't this a problem of the court in determining the time period? Because do you know the constitutional principle when it comes to separation of powers?
Yes, you are.
Okay, can you give us a little bit of one sentence? What does it mean?
The court may, the legislature may not intervene, may not intervene with the court, and the court may not intervene with the.
Okay, so in this case, authority is given to the court to make that determination, whether there's sufficient risk. So it shouldn't also be the authority of the court to make a determination as to the time period and to the individuals that are affected or the individuals involved in the case.
I'd like to contest that is now that provision that moment that instance is now resorting to judicial legislation, which is now beyond the provisions of the POCO Act, which says that all messages should be encrypted. If the judge specifies as to the time, then the judge will now be going beyond his discretion to actually go and interpret something for the law that is beyond its meaning.
Okay, so how do you suggest we reconcile this?
We can follow the frameworks that are provided in the issuance of cyber warrants in rules on the rule of cybercrime warrant, section 6.1. In this case, there are specific requirements as to which time can we decrypt these messages. For example, there's a probable cyberbullying case. We should decrypt the messages sent 2 weeks ago, only 2 weeks ago, not including more than 2 weeks ago. And that, I think, balances the interest of of my client and also the state in protecting the children. And I think that means, and we are here to advocate for that means, because it is not just my client Amanda Dcmcc, but all future Amanda Dcmccs. And if this is if this case is decided for the constitutionality, then this will set a bad precedent and a dangerous precedent as to the infringement of privacy rights of individuals.
Counsel, you will agree with me that there's a need to protect the children, as earlier pointed out by the presiding judge.
Yes, Your.
Okay, so we're on the same page on the protection of children as a
Yes.
vulnerable sector. Now, it is your submission, and correct me if I'm wrong, that the POCO Act is not the least restrictive means.
Yes, Your Honor, because it now violates the second
Okay.
requisite.
In light of all the matrix, the litany of laws, statutes that you earlier pointed out to this body, what now is your alternative, if I may ask, considering that you mentioned all other existing laws which, according to you, supporting your position is enough remedy? What is it? And follow up to that question is, will it not compromise the protection to children in consideration of the cyber scene, the dangers posed in the context of cyberbullying?
And I would like to contest. Should I still be allowed to, since the time is up? So, for the issuance of cyber warrants, Your Honor, we should follow that framework in order for us to be able to determine enough particularity and enough sufficiency and enough just enough means to be able to protect our children, and at the same time balance the interest of the protection of the privacy rights of our constituents. Thank you, Your Honor.
Sorry, just last question. Because I was reading section 4, the way that the law was worded out. And you're assailing section 4, right?
Yes.
The taking a copy of all the encrypted messages.
Yes, Your Honor.
Okay, so will you agree with me that encrypted messages are different from decrypted messages?
Yes, Your Honor.
Okay, so the way that the law is laid out in section 4 is that the PNP or the DSWD, in cases wherein the encrypted messages are stored in a local device, they will take a copy of all encrypted messages.
Yes, Your Honor.
Right? Encrypted, different from decrypted.
Yes.
Right. And it is only, and you have to read it in connection to section 2. You have
Yes.
to read the whole law in its entirety. And in section 2, it says here that although they have a copy of all of the encrypted messages, they will only be decrypted upon a lawful order of the court. So my question is, what's the problem?
The problem now is, Your Honor, we are not distinguishing as to the time of decryption of all messages. When
Yeah,
in
but
fact, we can resort...
sorry, Your Honor.
sorry.
Sorry, counsel. But if they have a copy of all the encrypted messages, these are encrypted messages. So they're not going to be able to read what these messages are. So if they can't read what these messages are, where's the violation of the right to privacy?
There is this violation of the right to privacy when there's this gap that since we have encrypted all messages, then we are in possession of all those messages, and then upon the lawful order of the court, that's where that absurdity happens. We are trying to protect children, at the same time we're trying to protect individuals. In this case, it is encrypted. Upon that order will now unlock which in this case, I'm looking at the cabinet full of messages, for example. If I have a lock from the court, then at the time that I open the court, all messages will be seen, and all those messages from individuals will now be, as opposed to just unlocking a portion of the court, a portion of the drawer, a portion of the messages that are
I
encrypted.
understand. But where is it found here in the law which says that the court is only supposed to order a decryption of all and not a portion? So are you now submitting that the law is phrased in a way that doesn't give discretion to judges to make orders in terms of time frame, period, and individuals or personalities?
So now, in this case, we should still, I would like to still contest that we should still interpret the law in its ordinary sense. Now, we should not distinguish where the law does not distinguish, and this has been upheld in a long line of cases in the Supreme Court. And which is why we should interpret it, the word all, in its ordinary sense, Your Honor. Thank you. Thank you.
When all messages were, and correct us if we are wrong, is it not correct that all messages were decrypted? And why decrypt all? Were the hands of the judge tied such that he or she had no choice?
Signed in this international convention on the rights of the child, wherein it is required as a signatory there that the government must put the best interest of the child as a primary consideration. So in national obligation, the PUPU Act was enacted by our legislative branch. As to the second question, whether all messages were decrypted and whether it is needed in this matter. Your Honor, we argue that all messages should be decrypted because there is no way to determine what constitutes cyberbullying in the case of Bertie and all the people in the life of Bertie. So allow me to proceed with my rebuttal, Your Honor. So in holding the stand that Section 4 is a form of unlawful search and seizure, in this case, Bertie has experienced emotional harm. However, the school administrator nor the enforcer has no specific knowledge about the person who committed the bullying act. Since Bertie is a child who requires protection, it is unjustifiable to feign ignorance of his situation simply because no evidence can be produced. This is in line with the Republic Act 10627 or the Anti-Bullying Act, which requires all elementary and secondary schools to adopt policies to prevent and address bullying in their institutions. So in this case, the headmaster and teacher promptly reported it to the SWD to investigate the bullying incident. Moreover, in holding that Section 4 fails to make a valid distinction as to the classes of people and messages affected, we argue that considering the inherent difficulties of policing the cyber world, it is necessary to apply exceptional measures. Extraordinary circumstance calls for extraordinary measures. The state aims not to access information, but to demonstrate that it must be emphasized that decryption itself does not serve as a deterrent. Instead, the notion that the state can access information deters malevolent activities in the cyber world. It is in the interest of the public to protect children in this case. In holding the POCO Act is based on something other than substantial distinction, we argue that when it comes to cyberbullying cases involving children, it's essential to consider their unique limitation and potential circumstances as potential communication barriers. Children may be unable to articulate their experiences and feelings clearly or effectively, making it difficult for them to seek help. So in such cases, decryption can be an essential tool to help provide these children a voice. As to the notion that the POCO Act does not pass the strict scrutiny test, we argue that while the right to privacy is a constitutionally guaranteed fundamental right, this right is not absolute. The Constitution states that the right may be impaired regarding national security, public safety. So in that same law, it is a valid exercise of state's police power regulating as opposed to completely negating the right to privacy of communication and correspondence. Let me honor request for additional 1 minute. Thank you, Your Honor. So, in holding Section 4 of the POCO Act needs to be more specific concerning how it is to be implemented, and it failed to provide proper protection and controls for privacy after the decryption took place, we argue that the POCO Act introduces measures such as judicial oversight and protective safeguards to ensure children's rights are upheld. So as to the contention of the applicant that the POCO Act lacks privacy protections on post-decryption, we argue that the POCO Act complies with the Data Privacy Act, which has a post-decryption mechanism. So, in this case, if it was found out that there was no manifestations of any cyberbullying in that decrypted message, then it will be securely destroyed by the law enforcement. As to the holding that there was no standards for implementing the decryption, we also argue that it is still aligned with the Data Privacy Act. So that ends my rebuttal. Thank you.
Just a final note. You may answer yes or no, or feel free to clarify very briefly. You're saying that the protection of the citizens' data privacy is inversely proportional to the protection of children's human rights. Yes or no?
Yes, Your Honor. Children as being a vulnerable sector, Your Honor.
So let me make that clear. So the more you limit data privacy, the better protection you afford or extend to children's human rights.
No, it's the other way around.
It's the other way around. So the more protection is needed for data privacy.
Your Honor, I would like...
And lessening the protection to children.
Because
somewhere in because I had to listen to the entirety of your speech so that I can put it in context, but I didn't find it sufficient. So I asked, you said that the indiscriminate or the unbridled access to data, therefore less protection to data privacy, tantamount to less protection of data privacy, is a prerequisite to protecting the rights of children. So can you just clarify that? Put that in context.
We argue that the POCO Act is not really about accessing information. It's more about protecting the welfare or the well-being of children. In that case, it does not mean that the privacy rights of anyone can be violated because, as mentioned in the Section 2 of the POCO Act, it is without prejudice with the Data Privacy Act, meaning it would in implementing the law at the back head of the law enforcers, there is still this Data Privacy Act that they must not violate.
So that should answer the presiding judge question earlier regarding so whether or not the judges, the RTC judges' hands are tied to issuing the order for decryption. So the RTC judge hands are not tied at all.
It's not tied at all because there is this presumption that the judges are very articulate or knowledgeable about the law. So in this case, they know that there is this Data Privacy Act that they must not violate.
Thank you.